1911. This is ASP Cares Pharmacy versus Auto Owners Insurance. The matter is before the court for the continuation of a hearing on a motion for summary disposition brought by the defendant auto owners in this matter. Your appearance for the plaintiff, if you will.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff, P number 84581.
Thank you, Madam Counsel. For defendant, if you will.
Yes, Your Honor. Julie DiBiase on behalf of defendant auto owners, P number 79916.
All right. I adjourned this over from yesterday just to look at a couple of matters that have been raised by the respective attorneys in here. The record should reflect that this motion for summary disposition seeks an order of this court determining that that auto owners is not responsible or not under duty to pay a benefits provider under circumstances where Mr. Sewell, who I understand is deceased at this time, did not appear for various MRIs. Anything further on your motion at this time, or an objection to the motion made at this time?
Yes, Your Honor. I just wanted to respond to what plaintiff brought up yesterday, which was the covenant case. They indicated they have a direct cause of action, so they're not tethered to Sewell's breach of duty, essentially. However, I'd like to point out to the court that that case actually stands for the position that a healthcare provider does not possess a statutory cause of action under the No Fault Act, which I think was the exact opposite point plaintiff was trying to make. There are also, I'm sorry.
You would agree that that case has effectively been overruled by virtue of legislative provisions.
Yes.
That allows for a direct cause of action. So I get to the point of being a direct cause of action, and I suppose that what Ms. Coley might have been saying, and I'll come back to you, Mr. Leslie, trying to get that name right. Is some of the language in the covenant case seems to detach the provider from the claimant, if you will, on the circumstances where there is an action brought by the provider. And I'll ask this question of Ms. Coley in a moment, but given the fact that there is the right to bring a direct action by the provider, and that is in fact what occurred in this case, is there a continuous chain, or does the chain break at some point? Because here you have presented without substantial dispute that I believe that for in the context of the motion, two MRIs in October, notices in October and September of 2020. I believe that you indicated that there was another notice in August of 2021.
That's correct.
Those MRIs that the claimant did not appear for the MRIs. So that for that reason, any benefits were suspended or not paid, and at some point the case was the file was closed in this matter because of the failure of the claimant to respond to the MRI. But this is a separate claim, or this is a claim brought by an entity that provided services. Where does the chain connect, and where does it break?
Well, Judge, the first distinction I want to make is that this involves a coverage issue. That's the issue here. So, for example, say Mr. Sewell unlawfully stole a vehicle and then got into an accident, or his accident was the result of him trying to run someone over. There's no coverage for that. Similarly, there would be no coverage for a medical provider's derivative claim as well. So the focus here is that there's no coverage. Second, I still maintain that TBCI is on point here and has not been overruled. In that case, State Farm properly denied benefits due to the patient's fraud. So there was no coverage for the patient's claim or the provider's claim. TBCI, the medical provider in that case, argued the same thing that ASP Cares is arguing here, that they had an independent cause of action, so the patient's case had no bearing on their claim. The court in that case focused on the issue of coverage. They said specifically that the patient's fraud spoiled the coverage, and here the failure to cooperate spoils the coverage. So it's the same argument. And again, they emphasize the provider stands in the shoes of the patient, even though it does have a direct cause of action. So I think the important distinction to make in looking at the statutes and the case law is that while they have an independent right to bring suit, they don't have independent eligibility. So while they do have an independent cause of action, their claims are dependent upon and derivative of the patient having a valid claim in the first place. So because Mr. Sewell's ineligible for benefits based on his failure to cooperate, the provider is also ineligible for benefits. Lastly, something else I want to say is just logically speaking, plaintiff's argument doesn't make sense because that would mean that insurers would have to pay claims that were properly denied for lack of coverage just because they have an independent cause of action. Here, auto owners properly denied benefits under the statute, the policy, and Roberts. So if auto owners would not have to pay Sewell's claim, then why should the provider be able to pursue a claim for which there is no coverage? So for those reasons, we ask the court to grant our motion.
Of course, you agree that that the TCBI case is distinguishable in that it does addresses the issue of fraud. I certainly agree with you, and I think it's an accurate argument that this has to do with coverage, and that fits into your motion in this matter. That if there is no coverage, then there's no cause of action here. But the cases are distinguishable because fraud is something quite different from a failure to appear at MRIs. But let me address that to Ms. Coleman. Ma'am, go ahead.
Thank you, Your Honor.
By saying to you, and I want you to make your argument. Well, I start out by saying to you that the TCBI case does seem to drill down on the link in the chain versus the break in the link in the chain. It seems to stand for the proposition that a claimant's a request for payment of benefits for services provided, and the service provider is not detached from the claimant. And so the issue here becomes to what extent is there an attachment and to what extent is there a detachment? Because if the defendant if the plaintiff here stands in the shoes of the claimant, then if the claimant, if coverage is denied to the claimant and they stand in each other's shoes, and it follows that the claim would be denied here. Go ahead, Ms. Coleman.
Thank you, Your Honor. I'd like to point out that defendant is asking the court for an extrajudicial remedy that does not exist. There's no court rules that allows the defendant to ask for such a remedy, which is dismissing the provider suit for Mr. Sewell's failure to attend the IME. The court rule does include remedies against the claimant himself for not attending the IME, but not against the provider. Further, the claimant died, and plaintiff was not aware of this until yesterday. Defense counsel notified the court of this. Like I made my argument yesterday about that Mr. Sewell's deposition took place in August of this year. However, defendant did not attempt to reschedule it, and we're not sure when Mr. Sewell passed away. So punishing the plaintiff for Mr. Sewell's failure not attending the IME is unduly prejudicial. Just to give an analogy, assuming there's a catastrophic accident that occurs and the patient dies in the hospital immediately or days in the hospital, this does not preclude from claiming or making a claim for no fault if the claimant dies. Furthermore, the claimant, the patient Mr. Sewell did go for multiple appointments related to his treatment and injuries, and there's medical records that the IME doctor can actually review and make a determination and findings if the defendant wants to make a finding on his overall physical and mental health. Therefore, Your Honor, I believe plaintiff's request from this honorable court to deny defendant's motion based on what has been argued by plaintiff. And I do take the position that the provider does have their own direct cause of action to make their to file with suit. As such, plaintiff filed its own suit to collect the medical bills, and therefore they're entitled for those benefits.
Right. So it seems that, well, let me just, before I make a vote in this matter, let me just address the issue of reasonable requests for attendance at MRIs, and the reasonableness of the defendant's request in relationship to Mr. Sewell. What other things have been done in this case? I know that the defendant attended a deposition. I know that there has been a significant amount of medical workup regarding his case. Certainly under the insurance contract, the plaintiff, I should say defendant, is entitled to request MRI and should not be unreasonably denied. Given the other factors in this case, where there has been the taking of the deposition, where there's been the submission of any medical records, the availability of any medical records that may have been generated, the availability of records related to the automobile accident, how does that weigh into the analysis of whether or not the court should deny allow the denial of the claim altogether under the motion for summary disposition? Either one of you can go first. Maybe Ms. Glazer, you should give your first name. Go ahead.
Well, Your Honor, while there has been work done in this case, we did take his deposition. As the court knows, I think I mentioned this yesterday, it's not the same. It does not equate having a physician actually examine him, licensed professional actually go through his injuries and be able to evaluate him in that way. Also, as the court mentioned, under the statute and policy language, we have the right to request such an exam, which we have been unable to do here. I also want to note we did give him a chance over the span of a year to attend these IMEs, 3 separate chances, and he has failed every time. And regarding his medical records, we have also run into issues with getting his medical records and having him sign authorizations. We have not really been able to obtain those records with him cooperating in that regard either. So honestly, luckily, he showed up to his deposition, but that's pretty much it. We haven't really been able to investigate this claim properly as statutes and the policy language would allow us to.
All right, Ms. Colby, you're correct at that, and then Ms. Glazer gets the last word.
Your Honor, they did schedule 3 different IMEs that were scheduled. The first one on September 23rd, 2020, October 28th, 2020. So there's like almost a month between the two. And the third one was in October 29, 2020. So all 3 IMEs were scheduled in a 3 months period. They have not rescheduled it, for example, this year, anytime this year, for him to go for an IME. However, they were they scheduled his deposition late in the year in August 2021, but have not attempted to schedule it earlier in the year and to have him give him a chance to attend it. And like I indicated yesterday, plaintiff is not aware of the circumstances surrounding the patient for not attending the IME.
All right, you get the last word, Counsel.
Thank you, Your Honor. As the court, I think, already knows, we did schedule an IME in August of 2021 this year, which he failed to attend. And honestly, we had to reschedule his deposition because he wasn't going to appear the first time. So, but that's beating a dead horse. Lastly, Judge, I just want to say, just to reiterate in TBCI that the provider's claims quite literally stem from the patient. And TBCI shows there's still a connection there. That's just the nature of no fault. A provider is not a standalone island. It stands on top of the patient. And if the patient claim fails, especially where there is properly denied coverage, there's no coverage. So does the provider's claim. The independent cause of action just gives them the right to bring suit without an assignment. But like I mentioned earlier, they don't have independent eligibility. So for those reasons, we ask the court to grant our motion.
All right. The court has listened to the argument on the motion for summary disposition brought pursuant to MCR 2.116C10. The party has the initial burden of supporting affidavit, deposition, or admission of or other documents. And the court would have to determine that in this case, the denial of benefits and the denial of coverage in this case premised on the failure of the claimant to attend 3 scheduled MRIs is a sufficient basis to preclude coverage under the language of the contract, as well as under the statute that allows for the request of such items under the no-fault law. It is without dispute that the claimant in this matter, Mr. Sewell, did not attend those 3 MRIs that were set up by the defendant in this matter, and that the defendant had the right under the contract as well as under statute to make such requests. There has been no formulation set forth on this record as to why and in what circumstances the defendant did not appear, whether or not there was some indication of any inability to appear, or what the issues may have been. We do know that the defendant later appeared for a deposition in this matter. We also know that the defendant generated a number of other medical records, some of which is associated with the services provided by ASP Care's pharmacy. The heart of the question in this matter is twofold. One is the extent to which the failure to attend the MRIs were unreasonable, because reasonableness is always a significant part of this. And then the second question raised here is how significantly or how close is the link between the cause of action that Mr. Sewell has as the claimant and the independent action that is brought, or the derivative action that is brought directly by auto owners insurance. In the case of TBCI, that court was able to determine with great specificity that there could not be a disconnection between the provider's claim and the claim of the claimant, because of the fact that the claimant's whole issue was a fraudulent one. That I can see where the court reached that kind of conclusion, because certainly if the claim is a fraud itself, then everything that it is built upon is fraud. And that court having concluded that the plaintiff's claim was, I should say, the claimant's claim was in fact fraudulent, then it would make sense that that any services provided to a fraudulent claim would certainly, it would make sense for there to be a denial of coverage, and it would make sense also that the court would rule in such a way that that denial of coverage was justified and was sustained. In this case, it's not as simple as that. This case is a case where you have some level of cooperation. You have records that have been generated, and there has not been set forth before this court any claim of fraud. And where there is not a claim of fraud, where there cannot be a claim that there is no information available for this claim to be investigated, I don't think that the provider's claim is precluded on its face, as it would be under circumstances where the issue is an issue of fraud. This is an issue where there was a failure to attend again, and there's a statutory right to require that. There is a contractual right to require that. But when I consider everything on balance, it appears in this case that there is a reasonable degree of cooperation, and there are records available from which the plaintiff, strike that defendant, can defend as regards to this claim. Moreover, there has been nothing raised by the motion, although I know the motion deals with the issue of coverage. There's been nothing raised by the motion that would tend to support any notion that the coverage or the claim for payment for services provided by Aspercare's pharmacy, that there is anything fraudulent or untoward or unsupported about that particular claim. For all of those reasons, I would have to conclude under these circumstances, while it is a close call, I would have to conclude that the motion for summary disposition in this matter must be denied, and that the plaintiff in this matter, it appears, has a cause of action that they can go forward with in regard to this matter. For that reason, I've denied the motion at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Good day.
You too, thanks.
All right, this is case number 21149963. This is Michigan First Credit Union versus Nicole Willis. The matter is before the court settling for a pretrial conference on today's date. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Wesley Neal on behalf of Mr. First, number 80307.
Thank you, Counsel. And we have on this Zoom Nicole Willis, please.
Good morning.
Good morning, Ms. Willis. I am good. This matter is before the court on the filing. I'm seeing now of a motion for summary disposition. Ma'am, did you get a copy of that motion?
Your Honor, I have the copies that they sent me. Please follow me when I'm about to discuss this case. The information that they sent me is the actual copy.
Let me do this first. Let me get an answer to my question. Did you get a copy?
Yes.
Let me ask the question. Plaintiff's motion for summary disposition. Did you get a copy of that?
Yes. Mm-hmm.
All right. And have you filed any written response to that motion?
I think I sent it in to you because I have not received the documents that I requested. I requested for.
Let me ask you a question.
Mm-hmm.
Did you file a response to the motion?
Yes, I responded.
All right. Thank you, ma'am.
Mm-hmm.
All right. So let me go to Mr. Neal now. I know that this is a complaint that was filed, and I'm looking at the file now. It looks like this was in March of 2021. And this complaint alleges a breach of contract in the amount of $5,847.34 as a result of a retail installment contract. And counsel, you have moved for a motion for summary disposition on this matter. It looks like this had to do with the purchase of an automobile. Is that correct, sir?
That is correct, Your Honor.
What's the basis of your motion for summary disposition? And then I'm going to come to Ms. Willis, please.
Your Honor, we highly rely on what was submitted in our motion, but in just very brief summation, the parties did have a contract which is not in dispute. The defendant defaulted on payments. As I stated in the motion, we sent the vehicle out for repossession, which I think there was some confusion as to what the status was. I conferred with my client and we've attached documentation to that effect. We are not able to repossess the vehicle. We received an insurance premium payout from our skip claim insurance company that reduced the balance. And thus we're seeking collection for the remaining amount, which is $5,847.34.
All right, so that is a deficiency amount because you were paid off under, on some of the claim regarding some insurance that you had, is that correct?
That is correct, Your Honor.
What the balance would have been if that insurance portion had not been paid off, sir?
I believe that's attached to our Exhibit 2, Your Honor. $15,409.84.
And that's what I was getting at. This was a substantial contract on this vehicle that looks like it was purchased. Looks like it was purchased in 2016, and the total contract amount was $27,890. It looks like, and it was to be paid over a period of 72 months. All right, so at the time of default, you indicated that there was some $20,000 plus that was owed on the vehicle, correct?
I believe based on the calculations I have, Your Honor, there was payments on the vehicle over time, but it was $15,409.84. The insurance payoff reduced it to the present amount, which is the amount that we're suing on.
All right. So you're saying that with the insurance and payments, it was 15,000 in some amount, correct?
Prior to the insurance payment for the skip claim, Your Honor, it was $15,409.84.
Okay. So the skip payment pays something like $10,000, correct?
$6,000, Your Honor. There was also a payment, almost $7,000. There was also a refund for CPI, which Your Honor is familiar as collateral protection insurance, when my client's missing insurance documentation for protection on the vehicle. We force place insurance. Some of that was placed back in 2018. There was a refund for $2,455, which also reduced the total balance.
All right. All right. So I'm coming to you now, Ms. Willis. The complaint, the motion in this matter says that there's no genuine issue of material fact. I received a document that you filed back in June, which was basically your answer regarding the case itself. I've looked in my file and I don't see your written response to the motion for summary disposition. But let me turn one other thing over, and I'm just looking through here. Hold on one second. All right, I am finding something now from November the 6th. In just one moment, ma'am.
Okay.
All right, so I read your response, both your initial response to the complaint as well as your response to the motion for summary disposition. A couple of things. You agree that there was a contractual relationship for the purchase of a motor vehicle. Is that correct, ma'am?
Yes.
Do you still have the motor vehicle?
No.
All right. Was the vehicle repossessed?
Yes.
All right. And when did that occur? How long ago now?
August 13th, 2019.
All right. All right, ma'am. So tell me what else you wish to tell me about this matter, if you will.
The only thing that I was asking for that I never received was the notice of intent. I never received that. And then we were talking about the deficiency notice because I never received what was the total cost? See, the information that they sent me was actually the money that they said that was owed from the loan, the actual car loan. So my question was, what was the actual amount that you sold the vehicle for? And what was subtracted from that amount, if anything was subtracted at that time that I asked for. I never received any information. You know, in the contract it stated, and I think this is on Exhibit 1. It stated if they repossessed the vehicle, and I think this is on letter Exhibit 1 on the back on alphabet F. It says if they redeem the vehicle, if they take the vehicle, they'll send you a notification so you can purchase the vehicle, or if they were auctioning the vehicle, or if they was gonna have a private sale. I never received any information. So now you coming back a couple of years later and you want to sue. So just like you want me to have the information, where is their burden of proof of this information that they repossessed the car and they sent me the notice of intent, and the what was the other paper? I think it was the deposition notice. I never received any of that at all. They sent me a packet of my bank statements and things of that nature, which I already have. I actually have all my documents of my bank statement, the loans that I signed when I first got the vehicle. I have all that. I didn't need them to send me that. I needed to find out what was the vehicle sold for, when was it sold for, you know, like, I'm just not understanding any of it. So don't I have consumer rights? Or no, I don't?
Well, I think you already know that you have consumer rights, but otherwise you wouldn't have the right to be in court. So I'm sure that was kind of a rhetorical question.
No, I just need a better understanding.
And you seem to understand some things pretty well. Let me ask you, this vehicle, how much did you own the vehicle when it was taken? It looks like there was a balance that was still there. Do you know?
What? Okay, can you repeat that? Because I couldn't hear you. Could you repeat that?
Yeah, how much did you owe on this vehicle at the time that they repossessed it? It seemed like it was still a high amount. Talk to me.
You know what? On the bank statement that I have, it says the 15,000. I don't have nothing that says 20-something thousand, because I think you repeated something about 20-something thousand. I don't see that.
Yeah, I was talking about that, I was talking about the initial contract. I was talking about when you first bought it. So it was about $15,000 old on the vehicle, and now their claim is for a bit over $5,000. What year was the vehicle?
2012.
Okay. Now, how many miles did it have on it? As best as you can recall, when it was repo.
Now I actually have documentation when I got the last. Oh wow! When I got the last oil change, and it was in June of 2019.
Okay. Now you don't have to have the exact number of mileage, but tell me what ballpark were you in?
Oh wow, probably like 200 and some thousand, plus somebody had sideswiped me. So that was my question. If you sold this vehicle, how much was it sold for? Was it sold to a private owner? Was it auctioned off? Like, I need some information.
Gotcha. Okay. Here. Let me do it this way. Then maybe you can talk in the breakout room to see if you can come up with an amount to settle. Here's your biggest challenge in just looking at this, and I will on emotion. I can get at all of that. But here's the biggest challenge. The challenge is that you got a car with a debt on it of $15,000. It gets taken from you. It has 200,000 miles, and it's like 7-8 years old. That vehicle is for you to get from 15,000 down to 5,000. If they sold that, if they auctioned that vehicle off with 200,000 miles, I mean, you're probably talking about getting $2,000 for it. Let's say they got 5,000 for it at the auction. That would mean you owe $10,000. Let's say they got 8,000. It would mean that you owe. You see what I'm getting at? There's no way that auctioning that vehicle, they would have got $10,000. So, through the benefit of some other insurances and what have you that they had in place, they were able to reduce that obligation that you had outstanding from 15,000 down to 5,000. So I understand your issue about what's the deficiency and what have you, but we could reasonably conclude that if the only thing was take the vehicle and sell the vehicle, you likely can still $1,000 on this. So obviously some other things. All right. So let me see if the two of you can. You need to. You probably want to talk about ways to kind of resolve it. It's something that's old because of the paper. What happens is when you buy a product, the paper becomes worth one thing, and the product is worth something else. So if you sign a contract, the car starts losing value, it gets older and older, but that contract is still there. So the contract could be worth $20,000, and the car at a certain point may be worth $5,000, but that doesn't reduce the contract. So what happened here is that some of this is beneficial to you in the sense that even though you owed about $15,000 when it was taken, that $10,000 is gone. $10,000 is gone already because of some insurances or whatever that were on the vehicle. So that saved you $10,000 there. And before I make my determination on this is that there's no genuine issue of material fact or dispute as it relates to a contract. And so the court would find that there is a breach of contract, that there was agreement and that agreement was breached. And the only issue that remains is the issue as to amount of damages, how much is owed. That is the issue. But in terms of the plaintiff having a right to judgment and a right to claim an amount, they have the right to do that because there's really no dispute here. Both sides say, yes, there was an agreement. Yes, we signed the contract. And yes, the contract was breached, the car was taken. The issue becomes of the $15,000 that the car was taken, how much of that should I remain obligated to? The plaintiff believes that amount to be in excess of $5,000. It seems that Miss Willis believes that amount should be less than $5,000. That's the argument. And so I will make a decision on that, but I want to give both sides a chance to talk about it. You need to try to see if you can reach a number that works and maybe a payment plan to try and get it settled. Come a long way from 15,000 down to 5,000. So I'm going to send a notification to you, Ms. Willis, and to you, counsel, to see if you have some room to talk about this a little bit. Given the fact the court has already ruled on one part of it, let's see if something can be worked out to try to get this resolved. Just one for everybody here. Okay. I see Mr. Neal, but I don't know why I'm not seeing where to click. Miss iPhone. Okay, there you are. There you are. All right.
Okay.
Let me know. Click into the breakout room and come back when you're ready.
Okay.
Thank you, Honor.
Thank you.
All right, this is case number 21157057. This is Momentum Spine and Sport Management versus Falls Lake National Insurance. The matter is before the court on the filing of the motion for summary disposition. Your appearance at this time, please.
Joseph Falls on behalf of the plaintiff, Your Honor.
Good morning, Your Honor. Teresa Bodwin on behalf of Falls Lake National Insurance Company.
Your Honor, before we begin, I know.
Let me get some P numbers and then Mr. Valzon, your P number, sir.
80521, sir. Sorry.
And my P number is P78913.
All right, thank you very much. Mr. Faison.
Sure. Before we begin, I want to apologize because I know you didn't get a response from me to defendant's motion. However, after review of the motion, and I've been sick and out of the office for 2 weeks, so I apologize. But after review of the motion, the only information that I need is, did the underlying patient cash the check that Ms. Bodwin forwarded to them? And if the answer is yes, then it would be technically a proper rescission. And if the rescission is proper, then there's no coverage for my client, and therefore defendant's motion should be granted. That's the only information that I need.
All right.
Trying to make it easy for everyone.
All right, very well. I'm glad that you're feeling better, and hope that you keep on getting better and getting stronger. If we need to adjourn this or something, we can certainly do that. It seems that predicate means everything. So, is this some type of settlement that occurred that cut off future benefits, or?
No, what it appears to, I'm sorry, Teresa, you go ahead. It's your motion.
You're also, if you're not feeling well, Joe, I thought I'd step in.
I appreciate it.
I have no issue adjourning for my colleague, Mr. Falzon, because he is a very kind guy. And not a big deal to push it back. I do not know if the check has been cashed when, sorry. And to answer the question of what this is about, the policy was rescinded. Ms. Hopkins, the underlying claimant, we do not have a case with her. She has not filed suit. We did send the denial letter, which is attached to our motion with the check. I have a feeling that she maybe has not cashed it, but I can check, because normally my client would send me the cash check. There are a number of cases that I just won a case in the Court of Appeals without a cash check, a provider case like this without a cash check. I think the big issue here, on a side note, is that Ms. Hopkins told us she was living in Westland and when she was living in Detroit, and it would cause a $2,000 premium increase, as well as failing to list 3 different household members. So it's a pretty substantial rescission, substantial basis for rescission. But I am more than happy to adjourn this to allow Mr. Falzon time to respond.
All right. Well, we wouldn't be so moved by your success in the Court of Appeals, but those other facts that you put out there could be quite substantial.
Yeah, yeah. It's a big premium increase. That's why this one's this one's a pretty big one. Yeah.
All right. Of course, we're moved by the Court of Appeals decision as well. All right. So let me set this over, and you want to try to get at this before the year is out, I suppose, right?
I'm open to however long Plaintiff's counsel needs to file a response or anything like that.
Mr. Falzon?
I would have, sorry, I would appreciate a couple weeks at a minimum.
You don't really have, Judge, you just don't. You only have the 1 week.
Can you squeeze it in somewhere in December?
December, not December, that's just that 1 week you have.
All right. It looks like I got to put you in January. She told me again.
I'm sorry for inconveniencing the court.
Yeah, there's no inconvenience. I have a bunch of cases you fit in. All right. So what day, Madam Clerk?
You want to do the 3rd, January the 3rd, Monday the 3rd, or the 4th?
January 3rd, 2022, 9:30 a.m.
Thank you.
And it's 47. All right.
I just want to make sure we'll I just want to confirm it's the court rules for reply briefs and responses, because I likely will have to write a reply brief as well.
Well, Teresa, we might be able, if we can craft an order, we might not even need to come back.
Okay. Okay. All right.
That's kind of what I'm anticipating, but the general rule here is that allow the other party 7 days opportunity to respond, and I'll hear it. Even if it's shorter than the time under the court rules, if you allow the other party 7 days to respond, then I'll hear it.
And do you need, Your Honor, me to file another precipice with the court for the MSD, or it's just being moved?
It's just being moved to the 3rd of January.
Okay. All right. Sounds good.
All right. Good day to the two of you.
Thank
Okay,
you.
Thank you.
Thank you.
All right. The court calls case number. All right, case number 21-156-394. This is Metro Med Pain Management versus City of Detroit. The matter is before the court for a review. Your appearance for Metro Med. Do I have the city of Detroit? Just one moment. The record shall reflect that the parties on the previous date agreed to send the matter to facilitation and set this date as a control date. It appears that the Metro Med and City of Detroit, that neither side has appeared on this matter. The court will order that the matter be dismissed within the next in 14 days if I do not hear from either side regarding any other direction in this matter. The matter has a pending dismissal in 14 days. All right, this is case number 21-153960. This is Michigan First Credit Union versus Asia Price. The matter is before the court. Looks like I set it on for a hearing on today's date. Appearance for the plaintiff in this matter.
Yes, thank you, Your Honor. Shannon Warner of Holzman Law on behalf of the plaintiff, Michigan First Credit Union, and my P number is 67017.
Thank you, counsel, and good morning to you.
Good morning.
Do I on this Zoom, Ms. Price, Asia Price, please? Looking for Asia Price, living at an address in the city of Detroit on Rutherford Street. If you're on the Zoom, please say something. The court did send out a notice with the, well, it looks like it gave the previous Zoom address. So Madam Counsel, you were able to find me this morning. Did you have some other notice of this particular address?
Your Honor, I was able to find you. I was directed to Judge King's courtroom, and they redirected me here, Your Honor. Thank you.
Very well, yeah, and that's what I'm looking at here, that this one, before, I used to be in 538, and so this one has the old Zoom address. I received the defendant's response or answer in this matter. And at the same time, I received an application for entry of default judgment. And so those things crossed over each other. It looks like, in looking at the answer to the complaint, that there is not a disagreement with the claims as set forth in the complaint, and that the defendant is raising the issue that the motorcycle, which was the subject matter of this case, was auctioned off. So counsel, is this a complaint for a deficiency in that regard?
Yes, Your Honor, it was. That was for a 2013 Harley-Davidson motorcycle. I would like to also point out, Your Honor, that we have not received a copy of that answer as of today.
All right. Yeah, that's unfortunately that tends to happen sometimes when the defendants file answers on their own. They don't set them. And I would indicate to you as I move forward in this case that the answer is as to items 1 through 5, and I should say 1 through 6. And regarding the complaint, the defendant agrees with 1, 3, 4, and 5. And as it relates to number 6, she indicates you do not know if the statement in paragraph number 6 is true. So it's basically a general admission and a general denial regarding paragraph number 6, which is the paragraph that alleges the amount of money that is due in this matter. And she indicates that she doesn't doesn't know one way or the other regarding that amount. Do not know if the statement in paragraph 6 is true. She doesn't answer paragraph number 2 about defaulting on the terms of the note. All right. Let me call once again for Ms. Price, Asia Price, in this matter. All right, given that the defendant has not appeared for the hearing on today's date, and given the court's review of the answer in this matter, the answer does not stand in denial of the claim. The answer pleads with regard to a auction of the motorcycle, and I believe that defendants seem to indicate to the court that by virtue of the motorcycle being auctioned, that there should be no further obligation. Plaintiff has submitted to the court that the amount that is planned for is a deficiency balance after the sale of the vehicle. Therefore, the court will enter the judgment by default at this time, where the defendant has not appeared as ordered in the record by this court. And I'm assigning that order at this time.
Thank you, Your Honor.
Good day to you, counsel.
You as well, Your Honor. Thank you.
All right, this is case number 21-240315. This is Jessica Floyd versus the budget lot. The matter is before the court, set for a pretrial conference. Your appearance for the plaintiff for Jessica, or do I have Jessica Floyd?
Yes, hello, Your Honor. Good morning.
All right, good morning to you, Ms. Floyd. Let me see if I have someone from the budget lot. Counsel for the budget lot, if you're on the Zoom, say something at this time.
Your Honor, it looks like they are here. They're paused.
I'm sorry, what?
It looks like they're here, Your Honor, but they're paused.
All right. Thank you, ma'am. All right, your appearance at this time, counsel.
Good morning, Your Honor. Ali Dagger, appearing on behalf of Budget Lot.
All right, thank you, sir. Good morning to you. What's your P number, if you will?
My apologies, Your Honor. 47354. 47354. We're handling multiple hearings this morning, Your Honor. We're just trying to manage it.
All right, we understand those kind of things. All right, so Ms. Floyd filed a complaint in this matter alleging damages in the amount of $6,500. And I see that you filed an answer in relationship to this matter.
We have submitted requests to admit, Your Honor. And at this point in time, we're seeking an opportunity to file a motion to dismiss under an SD motion to dismiss, Your Honor.
All right. So you have not filed anything yet, correct?
Not yet, Your Honor, because we were not given a schedule by the court at an initial pretrial. We were only given an opportunity to conduct discovery. We were awaiting the court's schedule as to when we can file an SD motion. Now that the discovery is over, I'd like to see if we can put together some time frame as to when it can be filed and when the answer will be required and when a hearing can be held.
All right. Ms. Floyd, you understand what's being requested and what's being said here?
No, I don't. If you
the defendant, of course, they are defending the claim, and they believe that they have a basis for asking the court to dismiss the case, and they want to file a written document in that regard, and you would have an opportunity to respond to that, and then the court will make a decision in that regard.
So,
go ahead, ma'am.
So, Your Honor, the discovery that they sent to me in the mail and asked me to answer a certain set of questions and then send everything back. I mean, what
Go ahead, ma'am. I'm listening. I'm sorry.
What more is needed from that? I answered every question. I gave all the information required. I don't understand what else is needed, or I mean, if you could just explain what's going on.
All right. Well, you have the right to pursue your case just as they have the right to pursue their defense to your case. And what they're asking me to do is to set the matter up for a hearing, at which time you could file motions, they could file motions, and the court would hear those motions based upon, it seems to be, they're going to file a motion to dismiss because they don't believe that you have a legal basis for the claim that you brought. I don't know if that's true or not, but they're going to file such a motion, and then you have a chance to respond to that, to the basis that they may be raising in this regard.
Okay. Why don't they feel like there's a case here? I mean, I was sold a car that technically is a limit, and when I took it off the lot, it broke down. So what's not real here?
All right. So did you buy that car as is?
I bought it as is. Yes.
That's likely the problem.
Okay, but
again,
Your Honor, that wasn't on the warranty, Your Honor.
You bought a warranty?
I did purchase a warranty. I did include that in the discovery documents.
Okay. Well, when they file their motion, that's what you're going to present to challenge any motion that they may raise in that regard. Is that this was a vehicle that was purchased with a warranty, and to the extent that is true, I don't know the facts, but when it's presented to me, to the extent that is true, then you may have a basis to rely upon your warranty. Purchasing a vehicle as is means that you purchase it without a warranty, and you are purchasing it just as it is. If you purchase it with a warranty, that will be something that they'll have to explain why they think it should be dismissed when you had a warranty. All right.
Correct. Sorry, ma'am. No, I was just saying, and also, Your Honor, in the discovery documents that they sent me, a lot of the information on there was false, which I did respond to some of the questions saying that these documents you guys are presenting to me is not what I was given by the individual that sold me the vehicle. So I don't know where they came up with these documents from, but they do not match at all.
Do they have your signatures on them at all?
Somehow they do. And when I was responding to the questions, I'm like, how is this my signature attached to this document?
Wow. All right.
It literally like they somehow copied my signature and stamped it onto these documents that they produced and sent to me in the mail. I was amazed, Your Honor. That's not what I have here. I have the actual original documents that I received when I was sitting in their office back in March.
All right, ma'am. So when a motion is filed, or if you file a motion, you'll want to respond to their motion or send your own motion and attach copies of the documents that you have, so the court can have that stuff in front of me when I make a decision. So what I'm going to do is I'm going to allow the parties a period of up to 30 days to file any motion that you want before this court. You have to do it within the next 30 days. And when I say the next 30 days, that means not later than December the 17th, by December 17th. And any response to the motion filed by December the 17th, the party responding to the motion will have until the 4th of January, 1/4/22 to respond to the motion. And the motion filed on the 17th and responded to by the 4th of January, I'm going to set that motion for hearing on January, just one moment here, the 12th, January 12, 2022, and that's going to be at 9:30 a.m. So if you want to file any motion with the court, you have until December the 17th. A motion is a document where you're asking the court to do something. It could be a motion for entry of judgment. You could say, Judge, this is what the case shows. There's no evidence against my case, and therefore I should get a judgment because of these reasons. And attach documents in that regard. The the defendant can file a motion saying the case should be dismissed for these reasons and attach documents. Either side file a motion, the other side has to respond to that motion by the 4th of January, 2022. And then I will conduct a hearing on the motion or the motions on the 12th of January, 2022 at 9:30 a.m., right? And you'll get a document in the mail from me with those dates on it. But bear in mind, you got to file your motion by the 17th, and you have a right to file an answer on or before the 4th of January, 2022, right? The hearing date will be January the 12th, and you'll get that in writing from me.
Okay. Now, Your Honor, should I ask your clerk how, do I come down there to file the motion, or?
There's a way to do it online, and you can come in to the building up to the 2nd floor to file documents as well.
All right.
All right. I wish you well, ma'am. Wish you well, counsel. I'll see you on the 12th of January.
Your Honor, if I may, ma'am, we will, is it okay for us to serve you by email? And you can serve us by email likewise? This is the same email you've had before?
Yeah, you can send me documents through email.
And likewise, ma'am, but do me a favor, when you send us a document, just to make sure it doesn't go into our filter, contact our office and let us know you sent it, please.
Okay, just.
All right.
Is that okay?
Now, would it be of any help for you, for the two of you to talk about this case in a breakout room to see if you can resolve this?
That will be fine.
I would love to, Your Honor, except I've got 2 other hearings to go to. Ma'am, you can call my office at any point in time for us to schedule a time together.
Okay.
Right. I'd love for you to be able to do that today, but all right, let's do it that way. See if you can get it resolved. If not, I'll hear it on the 12th of January. All right. Good day.
Thank you, Your Honor. Thank you, Judge. Bye-bye.
All right, thank you. Mr. Neal and
Good morning.
just one moment, yeah, let me see where I am now. And Ms. Willis, correct?
Yes.
All right, so you did have a chance to go in a breakout room and talk about this. What gives? You make any progress?
Yes, Your Honor.
Yes,
we
so
were
thank
able to.
you.
We're definitely able to clarify a lot of the issues around the case, and we've actually come to an agreement. We're going to get it written up, and I'm going to send it over to Ms. Willis. She's been kind enough to provide me with her email. I'll have her sign it and get it over to court to close this case out.
All right, that makes sense to me. Ms. Willis, makes sense to you, ma'am?
Yes.
All right, I wish you well. I know it's been difficult on both sides because of how big of a thing this was. Fortunately, there was something out there where the plaintiff was able to get money from other sources to bring your number down. So I'm glad you were able to work it out. And thank you, Mr. Neal, for your participation and working through this. All right, so I'll await your order and I'll consider that the case has been resolved.
All right,
Yes.
appreciate the court's time. Thank you.
Thank you.
Right. All right, this is case number 21-52185. This is City of Detroit versus Redeemed Christian Fellowship Ministry. The matter is before the court, set on for an adjourned final pretrial conference. There were some discovery issues that came up. This case appears to be a case where well, that's been going on for a bit. Your appearance for the City of Detroit at this time, please.
Good morning, Your Honor. Attorney James Varchetti, P79606, appearing on behalf of the city, the plaintiff.
All right, thank you, counsel. Good morning to you, sir. For defendant, your appearance at this time, please.
Good morning, Your Honor. Darwin Fair on behalf of Redeemed Christian Fellowship Ministries, defendant in this case, P number 31266.
All right, thank you, Mr. Fair, and good morning to you, sir, and thank you, gentlemen, for your patience in this regard. As you were able to observe, there was a little bit going on this morning. All right, and good morning to you, Bishop Apostle Smith. Good to see you, sir. All right. Good morning to you, sir. All right, so where are we with this? I don't see a motion for SD or anything along those lines. I do see a motion to compel answers. And Mr. Fair, why don't you update me on those items, sir?
If I may quickly, before, just to correct Your Honor, I believe that there was a motion for summary disposition that was previously filed, and the court in its last order took it under advisement. So there was a motion for summary disposition that was filed in this case. I just wanted to correct that.
Thank you, sir. I am seeing that, and I'm seeing that document dated September 21st of 2021. Yes, sir. All right.
Yeah, and Your Honor, it was my understanding that the motion for summary disposition was held in advance or taken under advisement until the discovery was completed. And I'm ready to address the issue of the court's order for motion to compel.
Yes, sir. Go right ahead, Mr. Fair.
Okay. Your Honor, the court did enter an order requiring the plaintiff to go forward with discovery, and they gave a date in question when that had to occur. I will say to the plaintiff's benefit that they did send me additional discovery. I have had an opportunity to review it. I have had an opportunity to review it with my client, and I believe his representatives reviewed it also. And so let me say this, Judge, they have, I would say, put forth a good faith effort to answer the discovery. If the court remembers, the issue was, number one, what property is in question with regards to the church's potential property tax liability. And that property, based upon, everything that was filed by the plaintiff, was with regards to a property located at 14210 Arlington. Now, my client on February 20th, 2014, had filed an application for exemption for real estate with the city of Detroit. And they had purchased, by way of land contract, a number of parcels at that time. 14210 was one of the properties in that bundle of parcels. So there's a question that has been raised with the city as to whether or not the application was actually filed, because they could not find it. However, we did provide them with a copy of the application. It was not timestamped. My client has stated a number of times that they did not timestamp it and apparently would not timestamp it. And I think there's a question as to whether or not the city would timestamp these applications. But having said that, the question became, in terms of discovery, how was this property treated outside of the years in question? That's number one. And number two, how were the other properties treated during the time in question and outside the time in question? And specifically, we looked at we requested from 2011 until 2020 with regards to all the properties and how they were taxed in the past. So what I did, Judge, is sent the court, and I sent the other side. I don't know if the court has had an opportunity to review it, because literally I sent it this morning. And I don't know if the brother counsel has had a chance to look at it, because I, again, sent it early this morning. But I will say this, what we try to do is create a grid based upon their answers to the interrogatories. So, I mean, and so the point of it, whether they're correct or incorrect, we still took their answers. And so if I can start off by saying, with regards to the years in question, 2014, 2015, and 2016, the documents that was sent to us showed that the property in question, 14210 Arlington, was taxed by their records in 2014, 2015, and 2016. We also wanted to know about the other parcels in this bundle of parcels that was purchased by my client on February 20th, 2014. And of those other parcels, which is 1, 2, 3, 4, 5, 6, 7, 8 parcels in total. On 2014, only one parcel was taxed, and that was 14210. There is a question as to whether 14227 was taxed, and I put that in parentheses because one document said it was, the other document, their discovery said it wasn't. So I put tax and I put it in the parentheses. With regards to 2015, the parcel in question, 14210, was taxed for 2015, but no other parcel was taxed. And then in 2016, again, 14210 was taxed, but there was no other parcel that was taxed except for this 14225 McKay, which I put that in parentheses because it wasn't clear if they were taxed or not. So what that showed, Judge, is that, you know, I called it the donut. You know, no other parcels was taxed except for this parcel, and my client had requested that all of the parcels not be taxed. So then the next question is, what occurred after that? And I will focus in on 14210. The plaintiff's records show that in 2017, 2018, it was taxed. But surprisingly, in 2019 and 2020, it was exempt. So why it became all of a sudden exempt in 2019 and 2020, that's a question for the plaintiff. Then I think the next important question was, what about before the church purchased 14210, and the plaintiff's discovery says that it was taxed in 2011, 2012, and 2013. So in other words, it showed, their document showed it was taxed all those years except for the last 2 years. Now, with regard to the other parcels, you know, outside of 2014, 15, and 16, once again, we have these parcels that were not taxed except for 14227 that was taxed on 2011, 2012, 2013, and then I've already discussed 2014. Again, what does that show? Well, it shows once again that that 14210 was what I will call singled out because the other parcels were not taxed, and this particular parcel was taxed by their records. And after 2016, you know, once again, you know, you have these other parcels that are not taxed except for 14227 for 2018 and 14225 for 17, 18, 19, and 20. And you know, there's, quite frankly, Judge, there's no rhyme or reason why a property became taxed and exempt. You just can't tell. But what is clear is 14210 is singled out as being taxed, even though my client applied for the tax exemption. And all these parcels were purchased at the same time as a bundle. So having said that, you know, it's our opinion that number one, our client on February 20th, 2014, requested all of these parcels be exempt, including 14210, which is the parcel in question. And again, when you look at all these parcels, you can tell it is clear that they were all exempt with a few exceptions other than 14210 Arlington. So it does raise without question the specter of why wasn't 14210 exempt by their records, and I like I said, Judge, I'll go by their records. why it wasn't exempt during 2014, 15, and 16 when other properties were.
And all of this, all of these parcels that you're making reference to, they are in connection to a religious operation or church and school type facility. What is it, Mr. Fair?
Well, okay, well, and it's a good question, Judge. You know, this was a, wait, let me back up. These parcels were purchased by Redeemed Christian Fellowship Ministries by way of a land contract. All of these parcels, one transaction. And again, most importantly, is my clients filed an application for to make sure that they were exempt, but it was by the church. The church purchased all of these parcels, and 14210 was one of the parcels. One of 2, 3, 4, 5, 6, 7, 8. One of 8 parcels that they purchased. And the city, of course, now is saying, well, although all the other parcels were exempt, this one wasn't, and we can't find your application. They can't say that they did not make the application. Only thing they can say is we can't find the application. But what is clear is that we have a copy of the application. And, you know, these other, you know, exemptions, like for this particular parcel, 14210, it was exempt in 2019 and 2020. Well, you know, I mean, the question becomes why? But with regards to the other parcels, they were all exempt, except you have a few exceptions that, you know, like this 14227 Arlington. It was, we believe, it's not clear that it was taxed in 2014, but it was exempt 2015 and 2016. It was exempt 2017, and then it was taxed 2018, 2019, and 2020. So it's just random. It appears from the information that they supplied to us of how these decisions were made. But one thing is clear is that 14210 stands out as why was this property taxed and the other ones were not.
All right. So, counsel, it almost sounds like, well, it sounds like an evidentiary hearing kind of thing that would make an inquiry into how the city manages multiple properties that seem to be connected to each other, where there is a religious nonprofit function taking place, and the circumstances under which an application is filed and or processed for exemption. So let me hear from the other side on this.
Certainly, Your Honor. I may be able to clear up some of the mystery that Brother Counsel has alluded to, because I don't think that the answers are necessarily all that mysterious for the most part. Just to sort of refocus the court, there's only one property which is at issue here where the city is suing for taxes, and that is 14210 Arlington. And as the record shows, and as Brother Counsel alluded to, that was, according to the city, taxable in 2011, 2012, 2013, during the years in question, 2014, 2015, 2016, 2017, and 2018. So the city showed this as taxable before the church bought it and after the church bought it. Brother Counsel asked the question, well, why was it all of a sudden exempt in the years 2019 and 2020? Well, I believe at that point, the church had no longer owned these properties, and it was transferred to the Detroit Land Bank, who is the current owner. And I believe the land bank is not a taxable entity. So that, I believe, resolves the mystery there as to why did it suddenly become tax exempt later. And as for the issue of, well, this, why wasn't an exemption applied? Well, again, the city's record showed that it was taxable before the church bought it, taxable while the church owned it, and taxable later. So it seems that the city never granted any sort of exemption. And there's also an additional fact that I want to bring up about the property as well, which is that 14210 Arlington is not necessarily like any of the other church properties, which were an actual church building itself, and I believe surrounding land, or maybe just the church building itself. 14210 was I believe, a freestanding residential home that was on the opposite side of the street. So while the church may have purchased it, it was not necessarily a house of worship, so to speak. It was simply a residential house. So given that posture, I think that's a distinction that the taxing authority can make. And additionally, if the church is going to challenge the city's decision to tax that property, as I mentioned in the previous hearing and in the motion for summary disposition, whether or not a property qualifies for a tax exemption is not something that this court has subject matter jurisdiction over. That's something for the taxing authority, for the Michigan Tax Tribunal to decide. And that has been brought up in my motion for summary disposition and in our supplemental briefs, that there's case law, there's statutes for the proposition that when an issue of tax exemption arises as to residential property, the trial courts don't have that jurisdiction to handle that matter. That has to go to the tax tribunal.
What are the issue of whether or not the city received or processed an application in this matter?
Well, that's something where, as Brother Counsel alluded to, he requested in discovery that we provide any sort of exemption information or any record of receiving any exemption information. And the answer that we have to provide is that the city retains any sort of information for a period of 3 years. So the period in question, 2014 to 2016, it's outside of that 3-year record retention period. So the city simply doesn't have any record as to whether or not Mr. Fair's client sent in an exemption. What we do have, though, is just the record of what properties were taxed or exempted. And for the one at issue, 14210 Arlington, the city shows it was taxable before the church owned it, it was taxable while the church owned it, and then taxable up until 2019 when it was transferred to the Detroit Land Bank. So for that property, consistent across the board, the city showed it as taxable, whereas for the other properties, or at least for most of the other properties, including the church building itself, that was the physical, the church proper, that was always exempt.
Could I say something, Your Honor?
Just one moment.
Okay.
What it doesn't address, none of the discovery addresses whether or not the city acted upon an application and whether or not any application may be given fair processing or anything along those lines. None of the discovery addresses any of those issues, correct, Counsel?
I don't believe that Brother Counsel's discovery addressed that specific issue. I believe it was limited to whether or not the city had any record of the church submitting an application for an exemption. If they didn't have that because of this record retention period, I'm not sure if they would have anything else either.
All right.
Yeah, but if I could just quickly chime in, and that, I don't want to put a monkey wrench in this, but we had an I'll call it, we had a Zoom informal discovery, and Brother Counsel wasn't part of it, but we did interview the people from the city, and their position was either we have it or we don't, and we can't find it. And that's why I didn't specifically ask that question in the discovery, because I already had an answer. That's number one. And then number two, they said that even if they did have it, it would be outside of the 3 years. So whether they have it or not, they don't know, and it's outside the 3 years, so they could have it, but their position is we don't have it. But I don't know how you can say you don't have it if outside the 3 years you don't retain it. So it's sort of counterintuitive, their argument. But having said that, I wanted just to make sure that the court understood where we were on that specific issue.
All right, Apostle Smith wanted to say something. Should I put him in a breakout room with you first to see if
No, Judge. I have all the faith in the world that whatever Bishop Smith has to say, that is the truth, and the truth will come out, period. So.
All right, thank you. Go ahead, Mr. Smith. Go ahead, Mr. Smith.
What I was going to say is he mentioned that it was a freestanding home and it was not. Can you hear me?
Okay, now, yeah.
Okay. I said the opposing counsel said that it was a freestanding residential home, which prior to us purchasing it, the church before us used that for their administrative offices because of limited office space and for their youth meetings. And that's what we used it for. We used it for our youth gatherings. So it was used for community purposes as far as our outreach to the youth and for our food bank. So it was connected. And then also, Your Honor, we never received any notification during the time that we owned the property that there were taxes due. After I had sold the building a couple of years later, that's when I got notification that there were past due taxes. So if there were taxes I never received a tax bill to let me know that this particular property was being taxed, because I would have went down and addressed this issue. So that was the issue also, that if they could provide documentation that they sent out to the church, even after we moved. I never received any overdue notices because I'm on top of the bills of the ministry. So I would have addressed it had I known that this particular property was the only one that was not tax exempt, because I put that particular parcel on the application, and I was told by the lady that took it that if there were any issues of the property not being tax exempt, that I would receive notification in the mail. So I never received any notification during the time that we was there. So I assumed that everything was fine until after we had sold the property. And then we got this bill stating that we owed for those years on a property that we was using for ministry.
And if Bishop, if that was it, I just want to follow up with that. Was that it, Bishop? Is that all you wanted to say, Bishop?
Yes, sir. I'm good.
Yeah, and Judge, I was going to address those issues, but number one, that issue of the notice of the taxes that Brother Counsel says, well, if you want to object to the taxes, there is a tribunal to do that. Well, that presupposes that you have notice. And once again, I will, take what they sent us in their discovery. They stated that the taxes for 14,210, for 14,227, and 14,225 McKay were sent to essentially the church. They said they were sent to the church. The problem of it is they don't say when they were sent to the church. And so if, the church did not get notice of it or or it was sent after they sold, they wouldn't know to object. And that's why this jurisdictional issue is factually not an issue or is an issue, because they can't hide behind the fact that we have to go to the tax tribunal, because that presupposes that they have notice. And again, when it comes to when it was sent, they're falling back on the 3 years of, well, we don't know. We just know it was sent. We don't know when it was sent. So, and then lastly, with regards to what the property was used for, I mean, the church purchased the property just along with the other property parcels. They did it for a reason. They did it for a church business. It wasn't investment property. And let's assume that it was a parsonage as a standalone. Well, that's still part of the church's property. So you can't get around the fact that, well, it was a standalone building and therefore it's not within the auspices of a church, that just is disingenuous. And so, you know, we're back to the same point, which is they haven't been able to establish that the church is liable for the taxes, you know, based upon their own answers to discovery. And then again, if you drill down on what their process is, they really don't have a process. And if they have a process, their process is over 3 years old. And so they don't know what that process is anyway. So I don't know where we get anywhere with that other than, you know, this is the information they gave us and, you know, it is their burden. And it's just really difficult to see how they can meet their burden under the circumstances of this case.
If I may respond to that, I'm afraid that Brother Counsel's argument is kind of in reverse. The jurisdictional issue, it is an issue, as we pointed out in our motion for summary disposition, as well as in our supplemental brief, which is, again, it's a matter of case law and of statute. The Michigan Tax Tribunal is the only authority that has the ability to hear that initial claim as to whether or not a property is exempt. District court and circuit courts don't have that authority. So as to Brother Counsel and Mr. Smith's contention that, well, this was a separate building that was used for church purposes, that could be true. I don't necessarily doubt their representations that that's true. But as for the matter of determining whether or not that use qualifies for a tax exemption, that would be for them to go to the Michigan Tax Tribunal to appeal that decision. That's not something that this court has subject matter jurisdiction over. And as a second matter about the city having to establish that the property is taxable, the burden is shifted, or it's not the burden that Brother Counsel is suggesting it is. And this is also under case law. If a taxpayer is contending that property is tax exempt, it's the taxpayer that has the burden of proving by a preponderance of evidence that the property is exempt. There's case law for this. One is Spranger versus City of Warren, 308 Mishap 477. So as far as the burden here, if Brother Counsel is trying to prove that this property was tax exempt, the burden is actually on him to prove that by a preponderance of evidence, not on the city. And he would have to do that in the Michigan Tax Tribunal, not in this court in response to the city's collection action. So that's the first point I would like to make. And the second point is that as to notices being sent out, the city's contention is that it sent out tax notices to 14201 Arlington, which was essentially the main church building that's there. At least that's my understanding as to what that address is. And as far as when they were sent, that was not, I believe that Brother Counsel didn't ask specifically when they were sent in the discovery. I could be wrong on that. I don't believe that was specifically asked, but just as a matter of course, they're sent during the tax year in question or at the general tax time. Whether or not the city would have any more information on that, I cannot be certain. But I simply don't know what more to say as to that issue.
Well, Your Honor, if I may just respond just real quick, just real quick. We did ask about when the notice was sent because that's obviously an important question. Because if it was sent after they moved out, they didn't have notice. And number two, the burden of proof. Well, yeah, the burden of proof went to us, and what we're saying, the burden has now shifted because of the facts and circumstances of this case, the totality of it. And I don't want to repeat the argument, but we've made our argument why the burden should shift. And then with regards to the tax tribunal, Judge, it's literally too late for us to go to the tax tribunal because there is a time limit there. Now, if Brother Counsel is saying that he will waive that, we would be more than happy to go to the tax tribunal if we can get a written waiver. But he wants to put us in a catch-22 that is not of our making.
May I say something?
Just a moment.
When you get a chance.
Just a moment, Mrs. I mean, I guess obviously it becomes the burden of the defendant in this matter to establish that the property was exempt. And it seems that on this record, with all of the information provided, that there was not an exemption during the period of time in which the property was being taxed. The question becomes, if the defendant church presented an application for exemption and did not receive notice of the taxation during that period in which they occupied the property, and then were notified at a later point that there was debt and taxes due and owing. And at that point, the opportunity to go before the tax tribunal and challenge these issues that already lapsed, then the question becomes, what can the defendant do at that point? Well, he's just left with, well, they didn't tell me until later. I filed an application. They didn't act on the application. I didn't find that out until later. They told me about taxes. And now I have no redress. I have no redress because I can't go to the tribunal. And therefore, in the district court, the plaintiff is saying that they should get judgment for an amount that they assessed at some point, and that they notified the defendant at some point after he sold the property and beyond the period in which you could seek redress before the tribunal. That just seems a bit problematic there as to, there's no question about it that in the right time and space with the right notifications, this matter should be before the tax tribunal. There's no question about it. That's where you resolve this. But then if you come and you say that you're basically not asking this court to enforce the tax laws, that's not what the city of Detroit is asking me to do. They're not asking me to enforce the tax law. They're asking me to enforce a debt. And the plaintiff the defendant is saying that debt, that they have a defense to that debt. That their defense to that debt is that they did not receive notice of it. They do not have a basis for which it was generated, and that indeed they filed an application to prevent such a debt from occurring. So this is not a court that is enforcing enforcing the city's right to collect taxes or anything. This now, what the city has brought before the court now is the city has brought before the court a debt, where the city says that a Redeemed Christian Fellowship owes us X amount of money. Oh, by the way, it's because taxes were not paid. It could be because they didn't pay some tickets or whatever, but the court is not enforcing the ticket. The court is not enforcing the taxes. What the plaintiff seeks for the court to do is to enforce a debt that has accrued. And the defendant has asserted a defense to that. And their defense to that is that the taxes were not properly, or the debt did not properly accrue, or that they were not properly put on notice of the debt, that it's not a proper debt because they didn't receive the information required by law in order for it to become a debt. That seems to be what this case is about. I'd love for it to be before the tribunal, but it seems like it's past that point where this is almost like, to use language that help all of us get on the same page with it, it's almost like an account statement. Yeah, it came from taxes or whatever, but it's an account now. And that account doesn't matter whether it came from taxes or a water bill or whatever. So it's sort of like if you're suing about a water bill and the plaintiff says, well, I left that property years ago and now you're assessing the water bill. And it turns out perhaps that there was somebody busted up the plumbing after we left, the water was running, and now you're assessing it against us. Well, for me, I'm not here to enforce the quote unquote water bill, but a debt that has become established. And then when that debt is established, if there's somebody that has a defense to that, I don't believe that this court can sit and say that if the defenses that they may have to this are not relevant because they could have brought that before the tax tribunal. Well, I'm still trying to sort through it. All right. So essentially here, the city has to prove not that there were taxes that accrued as such, or whether or not there are taxes due. The city has to somehow carry the burden of proof that this debt is a debt that should inure to Redeemed Christian Fellowship. And over and above any defenses, offsets, set offset the Redeemed may have, that this is an obligation that should inure to Redeemed. And all right. So, Bishop Smith, you had something to say, sir, and then we'll move on.
Yeah, they were able to find us. We had moved out of the church about a year and a half, and that's when we got the notice that the city was saying that we owed this amount. But they have a new process with the city assessor's office. When you apply for tax exemption now, they send out field representatives to make sure that if you are buying a home and it's your primary residence, or if it's a church, because that happened to us a year ago, where they send out a representative to assess the property to make sure, she said, that these properties are being used. So I think if they would have sent a representative out, they would have saw the name on the building. They would have saw that we were using it for the church purposes. So they've not really been making field visits to make sure that that particular property that they singled out was being used for religious purposes. They just started actually sending representatives out to make sure that this is actually a church, that this parking lot is being used for this, that this extra land is being used for that, because I know I had that happen probably about a year ago. And the representatives say that they actually, are sending more reps out in the field to verify that this property is being used for religious purposes. So I never had anybody, contact me to say, we're coming out to, look at this property in question. Can you meet me there, et cetera, et cetera. After we moved, they could have been sending the notices to the church that bought, which was Glorious Church, but we had already sent and put in for any forwarding mail to come to our new location. So now I get this notification a year and a half later that this $4,000 or $5,000 is due for taxes that we didn't know that we were owed, because I would have paid them. I would have tried to find out what was going on. Why was this particular parcel singled out from all of the other parcels when it was being used for religious purposes? So I think that's what I wanted to say, Your Honor, that they do now have, I guess, a new system or an enforced system in place where they do send field representatives out to make sure that property is being used for religious purposes. So I wanted to make note of that.
Thank you, sir. All right. So I understand then that the city of Detroit is relying upon its motion for summary disposition and basically attacking, if they have the right to do the jurisdiction of this court to consider any issues beyond the fact that these amounts arise as a result of taxation, and that the taxing of the entity is secondary to the city's rights and authority to tax entities within the city, and that any jurisdiction on that issue would inure to the tax tribunal, and that the plaintiff would ask that the court would enter a judgment based on the fact that this is not before the tax tribunal, and that the taxes, the obligation has become established because there was no contest before the tax tribunal. That's the long and short of your argument. Is that correct, counsel?
That's, I think, very close to it, Your Honor. The gist of it is that the specific defense that opposing counsel has raised about qualification for a tax exemption, that is specifically for the tax tribunal to address. That's really the gist of that particular argument.
Thank you, Councilman. And Mr. Fair, your basic argument on the motion for summary disposition is that it seems to me that this is allegations of a debt that has come as a result, certainly of a claim of taxation for which your client did not receive notice at the time that he occupied and owned the property, and also to which your client had filed a proper exemption in conjunction with this property that was congruent with and connected to, although detached, connected to a nonprofit religious operation. Correct, sir? Mr. Fair?
Yeah, and also, Judge, the other parcels were exempt. So it just further emphasized the fact that this 14,210 should not have been taxed, particularly when the church purchased 1, 2, 3, 4, 5, 6, 7, 8 parcels, and they weren't taxed. This is a one that stood out as being taxed, and there's no legitimate reason for it to be taxed when you look at it from the totality of the circumstance. Since they applied for it, they didn't get any indication from the city that it was not going to be exempt, and the other parcels were exempt, and they had always been exempt. So, in terms of a debt, this is just not a legitimate debt, particularly since, we have shifted the burden back to the plaintiff, and they're relying on information that they can't substantiate because it's over 3 years old. Their information is just pure conjecture. They can't say whether the application is in there or not. So there may be an application. And I wouldn't say that the city would fabricate the case that they didn't have the document, but they're just arguing, well, we don't see it, and that's it. And my client has made it clear that he went to the city. He filled this out. He comports himself well to the court and was told that if there's a problem, we'll let you know. He never got wind of a problem until after he had sold the property a year and a half later. This debt is not legitimate. We've met our burden. And again, Judge, if the plaintiff, they want to waive any statutory infirmities with regards to the tax court, which they can, we'd be more than happy to go to the tax court.
If I can briefly respond to some of the things that Brother Counsel has said. If there's an issue with jurisdiction in the Michigan Tax Tribunal, I don't think that that the city can waive a jurisdictional issue of that sort. And B, as standing up today, I don't have the authority to do that. But again, if there was any sort of jurisdictional issue, I don't know how parties can waive a jurisdictional issue of that sort. That's something that Brother Counsel would have to take up with the tax tribunal and appeal to the Court of Appeals if he had an issue with that specific argument. And I also object to stating that the burden of proof has somehow shifted away to the city. The city is relying on its tax rolls, and we've provided those to Brother Counsel. And it shows that this property at issue, 14,210, was taxed as taxable before the church bought it and after the church bought it. So the idea that the city is relying on conjecture, it's simply not an accurate representation of what the city is relying on.
Well, and Judge, I've been listening to the arguments. I heard one lawyer say, let's not beat a dead horse. And I don't want to beat a dead horse. But, the reality of it is that all these other parcels were exempt. This parcel, for whatever reason, wasn't exempt, even though there was a request for it. And so I don't know how else you can shift the burden. The city is just sitting back and essentially saying, Well, what if that's true? Because they can't really defend against it. What if it is true that the church did file their application? They can't say it wasn't filed. We have a copy of it. The only thing they can say is we can't find it. And so I don't know how our burden didn't shift when we have a copy of it, and we have all the parcels on that application, and all the other parcels are exempt, and this one was not. So, show us, city, by your proof and intake that the application didn't occur. I mean, this is supposed to be computerized. And show us that the notice was sent. And of course, they're sitting back saying, well, it was sent, but we don't know when. Yeah, we know when. It was sent after the clients, the church sold the property. So they're getting, what they want to do is take advantage of this 3-year period in which anything before that, they don't have to show. And therefore, if we shift the burden, their position is too bad. But back to the point, what's the point? Well, if their records show that we applied, then how does that change the outcome of the case? Well, that outcome would show that they didn't do what they were supposed to do. They didn't process the application. They didn't notify the church that the application was incorrect or they weren't going to go forward. And then they never notified them during the period that they were there that there was a problem. So, the city is doing the straw man argument. It's not our fault, and we don't have any documentation to prove otherwise. And only thing we can say, it was in our tax roll, that's it. No, not after we shifted the burden by showing what we show.
All right. Wow, there are obviously some critical issues involved in this case, and I started to consider this now from the standpoint of the plaintiff's motion for summary disposition, which was filed some time ago, and supplements to that motion has been filed, as well as answers to the motion has been filed. I gave occasion that the court might be able to consider all of the issues because of the various challenges that were brought to this matter. And so basically, the plaintiff takes the position by the filing of his motion to cite the statute MCL 205.71 that provides that all claims and offenses related to tax assessments are within the exclusive jurisdiction of the tax tribunal. I don't think that is an issue that is disputed in this case. The second issue that I don't think that is disputed in this case is that from the city's assessment standpoint, upon review of their records, they do not show the property that is the subject matter of this dispute as a property that was exempt at the time of the taxes were assessed. So the city's records do not show this particular parcel as an exempt parcel. Although the city's records do show that parcels that are connected to this property in various ways over a significant period of time were in fact exempt from taxes. Moreover, as a third issue that is not in any substantial dispute here, is that the properties were in fact used for religious purposes, purchased, used for religious purposes, and then sold at some point. The challenge then is not so much those things, because those things are pretty much established and not really a dispute. What is a dispute is the prong, which is basically item number 13 in the motion of the plaintiff, and that is because the defendant failed to object to the assessments within the time provided by the statute, the defendant waived or forfeited any claims or defenses related to those assessments. and the defendant is precluded from raising any such claims or defenses. And by that a statement in reference to MCL 205.735A, by definition and by inference, it points out that the defendant had a set of rights, a set of claims and defenses that could have been waived, and they could have been waived at a particular time in relationship to bringing this matter before the tax tribunal. What the motion does not do is it does not factually exclude the reality or what seems to be from the statements made by the defendant and by the defendant's counsel in this matter, that in fact they filed an application for exemption, that in fact they never received any indication of any taxation of the property, that in fact they didn't sold the property, and it wasn't until some later subsequent time that they received any information that the property that they had purchased and then later sold was in fact subject to any tax obligations or any tax liens, and that the application for exemption had not been acted upon, or that there was a claim that had not been received. And then further, we received information that any application that may have been filed would not be on file after 3 years, whether that application was acted on, not acted on, it would not be on file after 3 years. So that the part of this case that's the part of this the motion that seeks a summary disposition, which requires a predicate that says that the defendant failed to object to assessments and within the time permitted by law. Well, there's nothing here that supports that he ever, that the church, I should indicate, ever had the opportunity to waive or forfeit their claims or defenses regarding this assessment, because any notification in this regard was given at such time and juncture where the right to assert any defenses and claims would have long passed before they received the notification regarding any obligations. That itself is then a defense that could be asserted to the claim that has been presented before the court, particularly where this claim now has become simply a debt that's been presented before the court, and the predicate as to how and why and under what circumstances the plaintiff asserts that the defendant has a debt and obligation. The defendant certainly has the right to raise defenses to that debt. The defense that I never had an opportunity to receive proper notice of this debt. I didn't receive proper notice. I didn't receive the opportunity to challenge this. And so the court, the plaintiff was asking by his motion for the court to be a rubber stamp on a process that at least the court don't make this binding, but we're talking about a motion for summary disposition now, where I have to look at the evidence in a light most favorable to the non-movement on this motion. And if I look at it in a light most favorable to the non-movement on the factual issues, then certainly factually there is the claim that this debt arose under circumstances where the defendant church had no opportunity to assert claims that would have been otherwise permitted, that they would have been otherwise permitted to do so by law, and that their inability to do so was predicated on the failure of the taxing entity to timely notify them of any obligation and to timely act upon an application for exemption. Those are factual questions that remain in this case. And for that reason, the motion for summary disposition in this matter will be denied. And obviously, there are other issues here, but as far as summarily granting judgment in this case, under the circumstances that have been described on this record, the court court could not find a basis for granting the motion for summary disposition and granting judgment based upon the bill that is a tax bill that has become a claim for recovery of a debt before this court. So the motion for summary disposition is denied at this time. Just a couple of thoughts in regard to this matter. It would seem to me that this would push this into either an evidentiary hearing or a trial type setting. More likely, simply a trial hearing, just court to determine whether or not this debt is an enforceable, if you will, debt. The other alternative, or the other way of looking at this, is to think about whether there's any room to compromise in this and see if there's a way to settle this out and be done with it. I mean, I can't enforce anybody's hand on that, but that might be something that's at least worth talking about. Something went awry here, and oftentimes people talk about First Amendment protections in so many interesting kinds of ways. And I know that this is not a quote unquote First Amendment case, but when you talk about First Amendment, one of the things is the free exercise of religion and the issues that arise from that give rise to churches being able to experience a kind of tax exemption situation. But that is predicated on, and the federal laws allow this, that the local taxing entities can make a decision on that exemption on a case-by-case basis, on a church-by-church basis. So there's not a quote-unquote, the fact that you are federally exempted or 501c3, et cetera, does not rubber stamp an exemption for religious operations and religious properties and what have you. There are some people that feel that maybe it should, but it doesn't. The local taxing entities still have to make a decision on a case-by-case basis. But when that decision is made, or when an application is made, and that process is on the way, that process has to be a fair and reasonable process, and that process has to be what we all understand and appreciate: notice, due process, notice, and opportunity to be heard. And it seems like there may have been somewhere along the line that notice and opportunity to be heard, commonly referred to as due process. Somewhere it seems that the ball may have been dropped somewhere. I don't know that for sure, but some of what I've heard here suggests that something like that may have occurred. On the other hand, what I've heard here as well is that that particular piece of property as a subject matter of this dispute was taxed before the purchase by Redeemed, and then it was taxed after the purchase by Redeemed. So there are some peculiarities on both sides of this. There's no question about it. But the lack of notification to the church organization until sometime beyond the period from which they could really take action to try and undo this, it's problematic when you talk about whether or not the defendant has a defensive claim. They may very well be able to defend a debt that arises under those circumstances. And that's why the motion has been denied. So if the parties want to take a moment to talk about this, if the attorneys want to put you in a breakout room, if you think anything can be accomplished in that regard, then it might be worth doing that. Otherwise, I'll set a hearing. A lot has been put on the record. We'll put some stuff on the oath, and I'll make a decision after hearing the various pieces and components.
Your Honor, thank you, Your Honor. If I may, we have always extended ourselves to trying to resolve the matter, and that has not gotten us anywhere with regards to the city. That's number one. Number two, Brother Counsel, I don't know if he has the ability to resolve the matter. I know Attorney Richard Rusin does, and that may be more appropriate. I can reach out to him. But assuming that we can't settle because we haven't settled, and we're going to have a hearing or a trial, Judge, I would like to depose this Justin Barry, who's a deputy treasurer for the city of Detroit. He's an individual, Judge, that we had an informal Zoom hearing. And I don't want to get into, obviously, the specifics of it, but there was some information that we had asked for that we didn't receive. But what I would like to depose him on some of these issues that have not been answered by the discovery because of this 3-year limit, and to see if he could bring some clarification to the issue of the process for tax exemption, on how the city reacts to it. You know, what did they do to try to find these documents of the application? What do they know about the notice? And to lock those answers down, because at the end of the day, I think that they would have a bearing on the trier effect as to whether this is a legitimate debt or not.
Well, if I may comment on that before the court makes any sort of decision. Brother counsel is correct that if you wanted to discuss possibly resolving this matter in light of the current status of the case, you would want to talk to my colleague, Mr. Richard Rusin, to see if that could be resolved without having to go to trial or something along those lines. If this were to go to trial, I would object to requesting at this date a deposition of someone from the city, given the posture of the case and given that if you wanted to produce that witness for trial, it could be done at trial. Again, this case it's coming up on, I think, almost 2 years old, and there's been quite a bit of time to do that. If you wanted to do that at trial, that's one thing. Taking a deposition at this point, I think, is a little bit late to the game. But it would be my hope that this matter could be resolved, perhaps without even the need for trial.
Well, Your Honor, you know, again, we will pursue settling the case without question, Judge. But if we proceed to a trial or hearing, they have to have a witness. And I don't know what other witness they would have besides this Justin Barry. And we're not talking about a long deposition. It's not an imposition to the city. And if he's the person who's going to testify.
Mr. Fair, let me stop you for a minute. Okay. Yeah, the reality of it is that if I'm setting, I'm going to set the matter out as I have to, given the holidays or what have you. If there is time between now and the trial to do the deposition, counsel wants to take someone's deposition before that time, that's fine. I believe it all is fair when it comes to issues of discovery, as long as people are not, lawyers are not being abusive. They want to discover the testimony before the trial date, and they certainly could go about doing that. I do hear plaintiff's counsel on this, and that there's been much more. So I get that part of it. But Mr. Fair, if you want to take deposition, I'll open discovery for the purposes of taking the deposition of the person that you indicated that you wish to take the deposition. So I'm going to go ahead and set a trial date for this matter. And my hopes is that the parties get resolved. I wish Mr. Rusin was here now, whatever. Maybe the court could have some involvement in seeing if this could be moved forward to try and get it resolved, because while it is a substantial debt, like the counsel said, it's been going on for 2 years. I've only been on this docket for, I guess, the last 6 months. And I've heard this may be the second or third time that it's coming from me. So I noticed the motion for some disposition was filed, and I think it was sometime in 2020. So a year ago, at least a year ago. So yeah, it's there's a lot that's been involved in this. Okay, so we're going to set a trial date, and it looks like it's going to have to be late January. So I'm looking at the 20th of January. I can go a little bit further out, but the 20th of January, would that give you the time that you would need, Mr. Fair, to get the that deposition in, sir?
Yes, Judge, that's more than enough time.
All right, so I'm going to set it for 10 o'clock on January the 20th, 2022, 10 o'clock a.m.
And Judge, can I ask, is that a Zoom?
Yes.
Okay.
Yes, sir. All right. And, you know, if it has to be tried, there are certain things that the court I would suggest that the parties try to come up with a set of stipulated facts. And because there are certain things here that whether they are comfortable or uncomfortable, they are facts in this case that are stuck. And one of the facts in this case is that the city's tax roll does not show that this property was exempt. Another thing that's stubborn in this case is that, at least to this point, there is no indication of the specific date upon which the church was notified of the tax obligation. And there are other facts that have come out in the discussion here, that this property was in fact being taxed prior to the purchase by redeem and after the sale by redeem. Those are facts in this case. The critical issues in this case that make this perhaps something a little different than your case where a person received notification, ignored the tribunal, and then at some point an action is brought to collect on the taxes. And the person says, well, I shouldn't have to pay them. Is that it seems that process in between, that something happened where Redeem did not get the notice. Now, that's not a matter of fact here. That's one of the issues in this case. They did not get the notice, and not getting the notice, they didn't have opportunity to be heard. So now this is the debt where no notice, no opportunity to be heard, and the plaintiff wants judgment almost by default. Well, I've already ruled on that in the summary disposition, but on the ultimate question, and the court has to weigh all of those things. And what I'm saying is that I don't want to go over so much of what we went over today to set the platform for this, because there are certain things that that does not seem to be much of an argument against. The core argument here is that, at least it seems to me from the defendant's standpoint, is that we did not get the proper notice. We filed for an exemption, and we were denied a process because of the failure of those items. So that's what I would want the parties to drill down.
Your Honor.
Judge.
Yes, sir. Yes, sir, Bishop.
Would it be possible for me to contact the title company and my realtor? Because when we sold the property, if there were taxes that were owed, they would have been paid out when the property was sold to the church. I would have been notified if there were back taxes. And there was, when we went to close, there were no taxes on any of the parcels. So maybe I need to go back and find out, was that a slight on the title companies? Because that's their responsibility to do a title search on any back taxes before you sell a property. And the new church that purchased it, we wouldn't have been able to complete the transaction if there were taxes that were due.
And that's, you want to talk with your attorney, Mr. Fair, about those things. But obviously, as this was going on, I didn't ask any questions because I'm letting the attorneys deal with this. Obviously, there was a purchase of the property at some point, and there's a closing package that should have addressed any tax type stuff. And then the sale of the property will address taxes because of proration type issues. I wasn't bringing any of that up.
That's the purpose of the title company.
I was sure that it would come up somewhere along the line. Absolutely, those are issues that I'm sure Mr. Fair as well as Mr. Ricchetti would explore in advancing this matter to a trial setting. I just didn't bring them up because that's what the attorneys would bring.
Sure.
All right, so you got your data, we'll get that data out to you, in the mail, in the next few days, okay? I wish you well. All right, good day to you.
Thank you very much, Your Honor.
Your Honor,
Yes, sir.
I apologize for if I'm jumping ahead of anybody, but there was a case that was before you at 9:45. I just wanted to make sure you're, because I have to jump to an MSD in Wayne County. We are settled on this case, waiting for city approval, council approval.
That's that case with the city of Detroit, right?
Correct, Your Honor.
I called that and nobody was here, and I indicated a pending dismissal in 14 days if I didn't hear anything. What I'll do is I'm going to go ahead and issue an order that I issue in these kind of cases, and it's an order that says that the case is conditionally dismissed, given that the parties have settled and it was pending the city council approval. And upon approval and dispersal of funds, the dismissal will become with prejudice. If it's not approved, or the funds not dispersed, then the case will be automatically reinstated.
Your Honor, thank you. I misspoke, Your Honor. This is not waiting city council approval, it's waiting city approval. It's below the threshold for the council approval. So we're just waiting for the law department to agree to this. But a similar order would be fine, Your Honor, if that's okay with you.
Got it. Now, and I'll fashion the order as you indicated. Now, we are talking about the Metro Med, correct?
Yes, Your Honor.
All right, got it. All right, that's a subject 6394 for the record. Thank you, counsel.
Thank you, Your Honor. You have a great day.
Likewise to you, sir. Deborah, you good?